protect incapacitated senior, that his primary purpose had been perverted to line the pockets of greedy attorneys and professional guardians with the hard-earned life savings of the elderly. Now they can point to a new federal verdict awarding a whopping $16.4 million. Julian Bivens described this as a landmark case. And for Ron, it really put he and his team on the map. Before that, as I mentioned, Ron probably had one guardianship case. That case went out there, and now, fast forward 4 years, Ron, Grant, Victoria, that team, their phone is ringing off the hook, and literally from sea to shining sea, from California to New York, up north and south, clients are calling. People with a lot of money or none at all, and everything in between, have called their team for advice and representation in guardianship matters. So without further ado, I hope you all welcome me, or help me welcoming Ron Denman to answer some questions about guardianship. Grab a microphone. Thank you. So before we open up to the questions, I want to ask Ron just a couple of things to get started here. A lot of people have seen this movie, Ron. The first thing they'd ask themselves, if they don't have any personal experience with the guardianship system, is this real? Is this kind of thing really happening?
The answer is yes, and it's the second time I've seen it, and both times sit and have chills over how unbelievably real it is. Because it's a conglomeration of several different stories, but it is as real as you could possibly imagine. And as much as God, there's no way that could happen. There's no way somebody could just show up at your door with an order, take you away, sell your house, put you into a facility, cut off your visitation, and then you're from friends, take your phone away, just like they did in the movie, and you're sitting there completely isolated, and your family and friends are wondering how in the world this is happening. It is so real, it's scary.
So, Ron, obviously Hollywood or makers of the movie can traumatize certain aspects of it. Can you educate the audience here just a little bit on how an involuntary guardianship can come about in the first place?
Each state has its own separate laws, but for the most part, they're very similar. In Florida, believe it or not, anyone can file a petition against you and say that based upon their knowledge and belief, they believe that you do not have the capacity to do certain things, be it take care of yourself, take care of your finances, and they set it forth in a verified petition, and they file it with the court. And from that point, you're now subject to the guardianship rules. And from there on, it's what happens. As much as we have laws that tell us exactly how it's supposed to happen, depending upon the judge, depending upon the petitioner, depending upon the place where this is filed, you are now in the system.
So just for example, if we're in practical real-life situations, we're talking about people that are in nursing homes, the employees of a nursing home, for example, the employees of a hospital, obviously you have friends, family, people that just know you, neighbors, law enforcement. What are the typical kinds of situations where somebody might be petitioned without even their knowledge to be put into a guardianship?
Well, there's a number of different situations. For example, you may actually have a family member with the greatest intentions that will seek a guardianship to protect you from another family, or to protect you from a relative living out of state may seek a guardian to protect you from people that are exploiting you, your neighbors, your friends, whatever. There are reasons why family members may do it, but sometimes, for example, Mr. Bivens, the senior Bivens, he was in a facility visiting his ex-wife. I believe he had to have a pacemaker, so he's there in the wheelchair, and he and his ex-wife are sitting there. They're in their, I think, late 80s, and an orderly An orderly in this facility saw that he appeared to not be coherent, didn't see family members coming to visit him, so he filed a petition. And he filed a petition, and guess what? He gets paid for filing a petition. He has attorneys that get paid for filing the petition, and they assert that he is incapacitated. And then from that point on, what typically comes with a petition for incapacity is what's called an emergency temporary guardian petition. Someone will file that along with the petition for incapacity, saying that because of imminent danger to the finances of the person of this individual, Judge, you should appoint an emergency temporary guardian to watch over him until we have the full-blown hearing. Well, the standard for the emergency temporary guardian is much, much lower than, for example, a full hearing on whether you're incapacitated. So as long as somebody makes a showing, a judge will issue the emergency temporary guardian or appoint one. That emergency temporary guardian also serves as guardians in many cases. It's the role, and they have their attorneys. And their attorneys are used to this. The attorneys get paid because a guardian can't operate in Florida without attorneys representing them. So those attorneys will come in, and they come into court, and they will, seasoned litigators who know what they're doing, they will represent the emergency temporary guardians.
Ron, a lot of folks here might be thinking what I thought when you asked me to help on the team for the Bivens case. This doesn't happen to people with means, does it? Did Mr. Bivens have means?
You become a cherry. You are a cherry. The more means you have, Mr. Bivens came from Texas, oil and minerals for going back for generations. So the more resources you have, the more you're a cherry. Why? Because everybody gets paid from the incapacitated person.
So Ron, let's talk about that in just a moment. There was a telling moment in the movie where initially realized that after talking to you that was the emergency guardian appointed at first. So a guardian is appointed while the Lord has already been, without her knowledge, she's not present. And how can that happen without the person being present?
Well, according to the law, the person should be present. What happens in real life, it's easy for the court to believe that good cause exists for you not to have to be present, for there to be a waiver. For example, my friend here, Tasha Milanes, practices guardianship law as well in Sarasota. We were talking before, hey Tasha, how often do you see the person who's been alleged to be incapacitated in those emergency temporary guardianship hearings or even incapacity hearings?
Nearly 40 years, probably never. They don't show up. There's a statutory requirement that the ward be given notice, but notice is someone showing up at the nursing home like that, showing them a piece of paper, they're not really understanding what's going on, and then they file a piece of paper with the court saying notice was served. Notice was served, we fulfilled the statutory requirement. The hearing comes, the judge says, where's Mrs. Smith? Well, she was served notice, she's not feeling well today. Okay, well, let's proceed. It's usually less than a 15-minute hearing. And the hearing, and certainly in the regular guardianships, is a bifurcated proceeding, which means there's actually two actions that go back to back. So there's the petition to determine incapacity, which 5 minutes, 8 minutes, one and done. Rubber stamp, they're now determined incapacitated. Florida has what we call a least restrictive alternative, meaning if there's other things, they've got wills, they've got trusts, well, those things aren't present. We immediately move into phase 2 of the hearing, which is the appointment of a guardian. 30 minutes, you're in and out. You're done.
And what's even scarier, for example, I have my friend here, Thomas Foster, just turned 93 years old.
All right, let's give a little hand. Interesting thing in the movie, By the way, the Ron Denman look-alike in the movie, representing the Russian mob,
I like that suit, Ron.
he actually, it was so tough, he tries to make an appearance on behalf of the ward, and they wouldn't let him come in and represent the ward. Has that ever happened?
Well, that's why I call Mr. Foster my friend, because right now, I haven't been able to represent Mr. Foster. He had a court-appointed attorney appointed by the court. As soon as that petition for incapacity was filed, an emergency temporary guardian was assigned to protect his finances, and that emergency temporary guardian was given the right to contract for Mr. Foster, which means that before he's had any adjudication, any hearings, anything where they've gone into whether he really doesn't have his capacity, this emergency temporary guardian has the right to contract for him. And when he asked me to come aboard, called me, said, could you represent me? Went out to meet him. I'm like, God, this guy's telling me the story about when he was a firefighter 50 years ago, being in the military. I had such an incredible, pleasant 2-hour conversation with him, and I'm like, sure, let me call up the court-appointed attorney. I'm sure he'll say, no problem, Ron, you can come on. No, Ron, I object. What do you mean you object? The law says that until you're adjudicated to be incapacitated, until you have a full hearing with due process where you get to argue your case, you have a lawyer who's there fighting for you, until you've been adjudicated incapacitated, you have a right to substitute that court-appointed attorney. And what happened watching the movie? Just said, no, Mr. Denman, you don't get to come in. Wait, but Judge, here's the law. No, he doesn't have a right to contract.
But in the movie, when initially the incapacitated person, sorry, I'm a lawyer, but they're not represented by anybody, which to me that was pretty hard to understand unless it's like a TRO in the antitrust world where you can go in and sometimes ex parte. But there's no due process here.
Well, so the movie, the only thing that's probably more dramatic is because Rosamund Pike, does a great job. She's pretty, she did a wonderful job. But typically, the guardian, just like that, will be there with an attorney, and the guardian will be somewhat silent while the attorney is making the same arguments. But in Mr. Foster's case, for example, he had the emergency temporary guardianship hearing, and I reviewed the transcript. His court-appointed attorney comes in. He stipulated, agreed to the appointment of the emergency temporary guardian. So you're thinking, well, he must have talked to Mr. Foster. Mr. Foster said that's okay. Never met with him yet. Never even spoke to the man and stipulated away his rights. We're currently appealing the decision. We had an oral argument before the District Court of Appeals over this very issue that he has a right under statute to appoint an attorney, and you can't have an emergency temporary guardian take that away from him. So we're praying that we're going to get the result that we need, and I'll be able to represent him. But right now, even though he won trivia with his friends last night at the club, at 93 years old, there's an adjudication he's incapacitated, believe it or not.
So Ron, one of the other interesting things about the case, and one of the things that I know that you see every day, I remember when you were going into the Bivens case, and like I said, it might have been your first guardianship case ever, and you walk in, and there's the guardians, there's the attorneys for the guardians, and there's everybody else, and they all seem to know each other, and you're an outsider who had tried every other kind of case, and this is a new kind of case for you at the time, and they all seem to know each other, and you were kind of an outsider. And one of the things when I read the Palm Beach Post article recently, they referred to something called the Catch-22. Mr. Bivens was explaining that, you see the assets of the ward being diminished and kind of squandered away, maybe not as dramatically as the way the Guardian in the movie did, but still, it's being spent on guardians attorneys, and so forth. And then if you come in and contest it, that's great, because they still get paid to contest it. So you either let them diminish your estate, or you pay somebody to fight it, and then everybody gets paid out of it. How does that work?
It is a catch-22, and it's probably the most difficult part of doing the job that we do, because unless someone comes to me, and as terrible as it sounds, unless they really have some means to fight, it's impossible to fight. There's too many fights out there, and because the person I'm fighting against gets, if they've got their cherry and they're using the assets, they have all the means possible, and they love the fight. Ron, bring it on, come on, the more you fight, the more I get to build the estate, the more I get paid, and the more my client, who's a family member, has to fight and pay out of their pocket against, just to protect their own parent, just to see them. Christine Montante's my client. She came all the way from New York today. Her mother's in a guardianship, or her mother's actually not in a guardianship. This is how unbelievable it is. There were least restrictive alternatives, which means there's no guardian, which means that she should be able to see her mother. There is, under the court right now, a geriatric care manager, which is a person who needs zero medical training whatsoever in the state of Florida. No license, no medical degree, no CNA, nothing. This person is writing emails to Christine saying, I control everything. You heard the judge. I control when you see your mother. I'm going to be there supervising you. I'm going to watch. I'm going to listen on every single phone call. You're going to see your mother when I tell you you're going to see your mother. So when you're watching this movie, and I'm thinking about what she's feeling as she's watching this, and it's just heart-wrenching because of the amount of money she has to spend and the fight she has to fight in order to see her mother, while the others are all taking money from her mother's estate, whatever's there. They don't care if they whittle it down. They're the care manager, the attorney for the care manager, the attorney for the power of attorney, everyone is getting paid for mom while she's paying out of her pocket to fight this fight.
And hence, when we say that this was a comedy, for some people, it's not. The movie is not really a comedy for people like Christine. Ron, what can someone do to protect themselves from this type of situation?
Probably the most important thing that people can do is to seek someone to look at your papers, create a power of attorney, a pre-need guardianship, God forbid, advance directive, and make sure that they are familiar, that they've litigated, they know what's going on. They've been in court. Because what goes on in court is not what the books say. It doesn't happen the same way. You need to be ready. If you've got a pre-need guardian or if you have a power of attorney, you've got to go a couple deep. Make sure you've got an alternative, another alternative. Because you think that you've got a power of attorney for your spouse, for example. And if somebody says they're incapacitated, well, I've got a power of attorney. I can't tell you how many times that's just thrown away. No, all the court needs to do is find a good reason that this is not going to be a viable alternative. The power of attorney to the person has been accused of taking money from mom or dad. Accused. So no, you're a thief, you can't be the power of attorney. Or you've got brother and sister, they're fighting over who's doing a good job. Just, I'm not going to get into this, so no, we're not going to do that. We'll just appoint a professional guardian. Now you're lost. And that's what happens. Yes, Tom.
And to Ron's point, even when people have a power of attorney, in certain circumstances, not all, but a lot, the mere filing of the petition to determine incapacity, the mere filing of that with a court suspends that power of attorney. So someone has this thing old and cold, done by a board certified lawyer, whatever, next door neighbor files this thing, all of a sudden, that's just often suspends for maybe the next 3 months, 6 months, year, while this thing's working its way through the
It's
system.
just one of 100 different pieces of evidence.
Absolutely.
It's not controlling, it's just one piece of evidence out of a lot of other things.
And you don't have to do anything. You don't have to be an expert. I'm sure just Ron's expert. You don't even need an expert. You just file the piece of paper, and the other one just goes away. Like it never happened.
So what do you need to do to protect yourself? The truth is you need to have the paperwork in place. You need to make sure that if there's a potential dispute between you and someone else, you've got an alternative for your power of attorney so that you can go deeper and show the court there's another alternative. You need a pre-need guardianship so that you've designated 1, 2, 3 people to be the guardian, if the court wants to appoint someone, he doesn't go to the person who's been appointed every time, with the same attorneys appointed every time. You need to have the appropriate health care directive so that you have someone that cares about you is making those decisions. You need to have perhaps maybe even a trust so that you've got a trustee. You've got to build the levels, and you need to have in your corner, if anybody starts to see someone slipping into Alzheimer's, dementia, incapacity, you have to have somebody who knows how to really litigate in the courts, because I never get called in as a first attorney. Never. I'm always called in as a second or third attorney. Why? Because the first attorney, and they're nothing derogatory, they're the ones that are brilliant, much different than me, incredibly brilliant. They're writing these wills, they're writing the trust, they're doing the estate planning, but they don't have the experience fighting against some of these attorneys and know exactly what they're doing. They know the judges, they know how to manipulate the system. You need to have somebody, just there in the wings. So the truth is, it's planning ahead. And we think we plan by doing it, getting our will, getting our power of attorney, our basic things. It's a different day.
Ron, we're all kind of guilty of this. Probably every single one of us. Whoever hasn't sinned, throw the first stone, right? I did a will, took care of my stuff, but I did it 10 years ago. I designated my son, my daughter, whomever, to be my healthcare surrogate. Well, that person, since I did that, moved to 1,000 miles away, or that person's on vacation when the time arranged. So it's important, is it not, to continually kind of update these things. I mean, we're all guilty of not doing this enough, but have you come up with any situations where people have made these designations, but they're so old that they're almost irrelevant?
Almost always. Almost always. I mean, we do wills when we're in our 40s and our 50s, thinking that this will last us forever. We never know when something may happen, but I can't tell you how many times I'll see the estate planning documents from the 70s. It was a different time. The laws have changed, and I think Kazi, you see that as well, right?
Yeah, I'm a recovering tax lawyer, so I'm a board certified tax lawyer, but most of my days is appropriate trust and estate litigation. So we see it all the time. Stuff that doesn't work for tax purposes, stuff that's no longer legal, power of attorney laws have changed, we're using different forms, and you'll see stuff that just makes no sense. And then, God bless the people that have access to the internet, because, why do you actually want to pay a lawyer when you can do it yourself and you get LegalZoom.com, and is this document valid in all 50 states? Not so much, but I'll be glad to litigate that one. So yeah, hire a professional. It's always cheaper to do it right and get the right people. And not a commercial for Ron, but I've done this for a long time, and I've dealt with a lot of trial lawyers. I had the pleasure of being with him for 2 weeks in trial. Honestly, Ron, probably the best trial lawyer I've witnessed. Within my area or without my area. Just as a civil litigator, but as a trust and estate.
He also handles overdue library book cases.
Yeah.
Very, very good.
Well, the truth is, I have a great team. Chuck Babel tried the Bivens case with me, along with Grant Kindred, Victoria Pierce. I'm only as good as the team. I've got some brilliant people behind me, and they help me. I just forget to go in and argue the stuff they put in front of me. But it takes a lot of effort. Again, you're fighting against sometimes the ward may have $100 million estate, a couple of $100 million estate. They will have an army of attorneys fighting me. An army. In a recent case, Chuck went down. I said, Chuck, you got to come into this mediation. Rob, you got to come into this mediation with me. Why, Ron? I mean, you can go do the mediation. Why? Because there's going to be 17 people around the table representing the money, and I'm just sitting there alone. Please I don't care, you guys look great, dress nice, come next to me. I need some assistance,
Sure.
But I'm not kidding. 17 people around the table.
Ron,
Yes.
Would you let these folks know, though, this is what was so stunning to me. We're sitting in that conference room with 17 other lawyers, and who is paying for those 17 other lawyers?
Oh,
One person, the ward.
yeah.
The ward, who has no, in this case, no idea in the world how much money she's got, how much money's in the bank, who's billing what. What's happening is just petition after petition for fees after petition for fees. Just check out, get a load of this. The mediator billed $650,000.
Who paid for that, Ron?
The ward.
So get it? It's the golden egg that the goose laid.
How do you object? The board can't object to the attorney fees because they're very capital. So who is there to object? And what part of the probate process Ron is reviewing these bills, the frequency of them, the paralegal bills, the variety bills, the sale of assets? Who's looking at this?
The judge is supposed to look at it. So what happens, for example, in a case like Christine or like Julian Bivens, the attorneys for the guardian will submit a bill, but sometimes they'll wait a year and a half till it's a $500,000 bill. They'll submit it. It could be 100 pages long, line item after line item. We will have to go and object to every single line item. Then we'll have to go into court and essentially have a trial over this. Okay? What do those attorneys think? Come on, Ron, this is great. Hopefully the trial will be 5 days. Let's do some depositions. Let's get some experts. Meanwhile, we're going to bill Mom for everything that you're doing to object. And if you're successful, Ron, you may take off 50 grand of that 500. You may take off 100 grand. Meanwhile, we'll bill 200 in the time you're fighting that 100. And guess what? And Christine or Julian is paying out of their pocket for that fight.
So what were the components of the judgment that you got?
Of which,
Well, the six,
The Bivens case?
yeah.
Yeah, the components of damage.
so the components of damages were that the attorneys were putting their own interest above those of Mr. Bivens. They're out telling the court they need to sell property, they need to liquidate his assets. For example, they sold a building in New York saying, Judge, we need to sell it. We've got our expert up in New York. It's a $5 million building. We need that, Judge. Meanwhile, they had $1.5 million in fees that hadn't been paid because there was no liquid assets. So that would be the component.
No, I'm talking about how for the dollars to be refunded to the ward because of the misappropriation of their assets?
Essentially, yes.
That's what I'm asking.
Yes. So it would be the economic damages caused to the ward
Right.
by virtue of the negligence. However, I don't really get to come in and sue those attorneys until the ward's passed away.
Oh, but you mean they don't get the ward doesn't get the money until they die?
Because the only person who has standing to sue these attorneys is the ward or the guardian. Because
Ron, please, let these folks know, because this was a landmark case in Florida.
Right, because I had tried to come in before. Just no. You didn't hire these attorneys. You don't have the relationship. You don't have this contractual relationship. No, Mr. Denman, Julian is a son. He cannot sue the attorneys. So when Mr. Bivens passed away, then Julian, as a personal representative of his estate, steps into his shoes, and he now is able to bring the claims against these attorneys just as though he were the ward. And until that happens, it's difficult. So you sit back and you watch somebody stealing the money, and you're fighting, but you don't get to bring those claims until afterwards. And when I come in to fight as a PR, then you've got a guardian and their attorney saying, no, they shouldn't be the PR. Because they're going to sue us, Judge. They're going to sue us, and that's not fair. They've got a conflict of interest. So in this case, we actually had to go to federal court. They tried to kick us out so many times, and fortunately we were able to go to the trial. But when you're, the entire case is I'm fighting these attorneys who are board certified. They've been doing this 40 years, and and trying to explain to the jury, I don't know, Mr. Denman's just trying to make money here. His son stole from his father, Denman's trying to make money, and meanwhile, we're just doing what's great for the award. We're just acting in the best interest here. You know, ladies and gentlemen, we're just, you think we would do anything wrong?
Ronnie.
And that's it.
Ronnie, respect, let these folks know though, before this verdict in Florida, had any court ever held that an attorney hired by a guardian had a duty to the ward? Explain that situation, because this was groundbreaking law.
The ward, I'm sorry, the attorneys for the guardian are hired by the guardian. Okay, they're not hired by the ward. He can't hire them. He doesn't have capacity. They're hired by the guardian. They're paid by the ward's money, but they're hired by the guardian, so the guardian's attorney. As a matter of fact, there was a new law that came out not long ago that all the communications between the guardian and the attorney are privileged. So even though I'm the ward and I paid for it, I can't even see what they're doing. I can't even see if there's 5 attorneys. I can't see what they're saying to each other about what they want to do. So as you know, you're pointing out, until this case in Bivens, there had been an attorney general opinion. There had been one case that stood for this proposition that the attorneys hired by a guardian do owe a duty to act in a fiduciary capacity, meaning a high standard, a high duty of loyalty to act for the ward. But it had never been tested, it had never been presented in a court where you're trying to get damages. And you know, with Grant, with Victoria, I can't tell you how many nights and how many briefs and, you know, and what we had to do to get to that jury trial. But thankfully the judge let us go. I don't think he ever expected it would get where we thought it would get. But it was the first time that people, attorneys, really stood up and thought about the fact that, geez, I can get sued. When I went in to Mr. Foster and asked the judge, hey judge, here's a statute, I know we're here kind of, you know, I don't know why this guy's objecting, but here's the law, I'm gonna come in for Mr. Foster to be his attorney. First thing that the attorney for the emergency temporary guardian said, no, Judge, Denman just comes in and sues everybody. He just wants to sue, so Judge, I don't think we need to have him come into this case. You're damn right I'm going to sue. When you steal from him and you waste his money, I will sue you. Just as I should be sued if I do something wrong. That's what we're here for, is to protect the laws, protect people's assets, protect their visitation. That's the most important. That is the most heart-wrenching part of this entire job, is to watch tears in Christine's eyes as she's thinking, as we're seeing emails today that are exactly what's going on. No, you can't come see your mom. Well, I'm coming down to Florida. I can drive down. I want to see her. No, sorry, I'm busy. I'm too busy. Yes, ma'am.
The medical collaborators seem to be the impetus for a case like this, correct?
I'm sorry.
Medical collaborators, medical professionals who would somehow deem a ward as being incapacitated are the impetus to most of these cases, correct?
Well,
And if so, would that not be the time for a ward's family to be getting an attorney involved on the defense to help that ward not be incapacitated and get to that?
Well, you asked two significant questions. Let me break it down. The first is medical collaborators. When there's a petition for incapacity filed, the court must, I think it's within 10 days, 5 days, 10 days, must appoint examining committee members. These are 3 people that are supposed to perform an examination of the alleged incapacitated person, render a report within about another 10 days, and identify all of the rights under the law that they believe this person should have somebody else exercise on their behalf because they can't exercise it. However, these are not necessarily all board-certified trained psychiatrists or psychologists who specialize in elder care. The law says, and you know, going by memory, it's 3 people. They're usually on a rotation with whatever court. And if you're lucky, they'll spend 30 minutes. There's no obligation for them to look at prior medical records. They may look at records if the family members gives it to them about prior conditions, how they are, that they're capable, but they don't have to look at it. And you would think that this person, what would any doctor do? Oh, I need to see your prior medical records so I know your history. They'll come in and perform these mini mental evaluations, look at somebody for about 30 minutes, leave, they'll write their report. I've had examining committee members where it was a nurse who's holding herself out as a psychiatric nurse. Meanwhile, she hadn't even come close to completing the things necessary. But she said, well, I read the petition for incapacity. It said that this person was exploiting the woman. Okay, well, that's just a pleading. It's allegations. There's no proof. No, I took that as true. So here's somebody who's having to make the incapacity decision. They're accepting things as true. So they're really not giving you that full objective evaluation. But if 3 people, as a matter of fact, it doesn't even have to be 3, it can be 2 of them. One person could say, I don't think that this guy's really completely incapacitated, but if 2 people say it, the court can look at that evidence and accept it. The ward doesn't necessarily even get a chance to speak, or the person who's alleged incapacitated may not even be there. And when I talk to them, well, what happened in court? What'd you say? I wasn't there. What do you mean you weren't there? Nobody let me come. Nobody notified me. I didn't even get to go to court.
Ron, in the movie, the person that petitions the initial award for incapacity was the family physician or the treating doctor of the ward. And what you're suggesting that a lot of these times, the treating doctor, the ward's own doctor, doesn't even testify. The ward's doctor doesn't even, that records, his records or her records aren't even really in consideration some of the time.
It's one thing when the examining committee member doesn't necessarily have to read the records to get the true version. What's even worse is if an attorney comes in on behalf of the family member, says, wait, my dad's not incapacitated, let me show you all of his medical records from his treating physician. And the judge said, no, I don't want to hear that person. No, you can't do that. Or says that you don't have the right to talk. When Susan Melendi isn't even permitted to object, even though the law says you have a right to object, you just scratch your head and go, how? How's this happen? Just like you're looking at the movie. No, come on, how's this happen?
And not even ADA accommodations.
Right. And Mr. Foster has hard hearing, couldn't even get the ADA accommodations he needed. I know, you're like going to say,
so who writes the laws in the state of Florida? And how many of them are lawyers?
And what they not to make sure that.
Brucey, come on, baby.
I'm sorry.
They're all lawyers.
Hold on, one at a time here. Annabelle, what
What can we do to prevent this? I mean, we live in Florida where there's a lot of people that are. What can we do? Look, I'm not an attorney. I'm an accountant. So people like me, what can we do to prevent something?
You're better then. You're better because you may get listened to more than an attorney who purportedly has an agenda. What can you do? Contact your legislators. Grant has been working trying to talk to folks in the legislative branch in order to make a difference. The biggest problem, the amount of money that's generated on behalf of the folks, the guardians attorneys, the guys that are in the mix, they spend a lot of money lobbying to protect what they have. Just like lobbying to make sure they've got this law to protect attorney-client privilege. Lobbying to make sure that every guardian has to be represented by an attorney. Why? I mean, why?
Well, a lot of times, the guardianship law was obviously put in place for the purpose of protection of people. It just has one of those things where there's the bureaucracy involved and the conflicts of interest and things of that nature that come into it. But the law itself is obviously intended for a noble purpose. And it's just the people behind it sometimes, you get the bad acts, you get the conflict of interest and the bureaucracy involved.
And that's true. We do need to have the laws. I get called in, nobody calls me in a good case. They don't say, everything's peachy, Ron, can we pay you some money to come in and look over things? So I only get called in where there's problems. So I probably am giving you the perspective of the problem case, and the reason that I'm so passionate and I'm explaining this is because any situation could potentially be a problem. And that's why if you plan ahead and you do things the right way, I think you can decrease the risk. That's the most important thing, is to plan ahead and speak to somebody who really knows what they're doing, knows how the system works, know how the judges work. That's the most significant thing. But you do need guardianship laws. We do need to have protection. We do need to prevent exploitation of elders. I'm sorry, yes, sir.
Yeah, so with all this being said, can this battle be won?
I know I'm going to keep trying. And I ask myself the same thing, but as long as I can just keep winning one after another and keep fighting, little by little, I certainly hope so. Can the war be won? I just know right now we can just keep fighting the battles.
Yeah, so the other question that I would have to that is that in the poverty-stricken communities, in particular the Black communities, they don't have that level of education. They don't have the level of means to understand what's happening. How do we now educate them that this also is something that can happen to them? And who do they seek? Because I have a great friend here that I can seek information, but they don't have that same outreach to find out, what do I do? How do they find this information?
In any poverty-stricken area, you're really not going to have as much of an issue as in, for example, Palm Beach. Why? Because if someone's in poverty, there's not a lot of money to pay the guardian and the attorneys for years and years of litigation. I don't ever see situations where there's big fights when somebody doesn't have a lot of money. Because who's going to pay the guardian? Who's going to pay the attorney? The state's not going to do it. Who's going to do it? I'm serious.
Right.
That's why you're not going to have that problem. Why do I spend a lot of time in Palm Beach? Think about it. This is where you've got gigantic estates, and some of the cases that we've had are astronomical numbers, like monopoly money. You can't imagine it. But as people are all pulling that money away, it is a monopoly. They're taking millions from an estate to fight over things that you could not imagine.
Ron, one of the, we have a question from Facebook Live audience, and it was talking about specifically some of the courts involved, some of the different counties. What I wanted to ask you about is the Bivens case was a federal court, right? And what is the differences, and how do you get a case into federal court versus county court in these situations? And what are the implications and the differences in a guardianship type of case, being a county court versus federal court?
Well, the only way to get a case into federal court, especially a case involving professional negligence, breach of fiduciary duty, it is by, in order to get federal jurisdiction, you have to have what's called diversity. So in Mr. Bivens' case, we were able to get him back home to Texas, unfortunately only 30 days before he died, but we got him back after 5 years of fighting. And because he passed away in Texas, as a resident of Texas, we were able to use diversity jurisdiction, meaning when you have fights between citizens of different states, you can go into federal court. But in a normal, almost all situations, that's the one thing I'm asked every time, please get me into federal court. If you've got a daughter or a son that wants to go after a guardian or an attorney on their mom's estate, and they're all in Florida, they're all in counties, there's nothing I can do. I can't get it into federal court. I can, however, there are situations where you can either seek a surcharge, which means I go before the same probate judge or guardianship judge that has been awarding all the fees and ask them to penalize the attorneys are the guardians, so I don't really like to do that, so I can go outside and just bring a normal case in circuit court. Obviously, the guardians and the attorneys don't want that to occur. They want to be judged by the same judge that's been ruling on them. And I don't mean to disparage judges, because one, I'm not permitted to. Two, I think that sometimes judges have the right intentions. It's just, as you saw up here when the guy was trying to fight judge, you're being fed the wrong information. But when I come into a county, never seen a judge before, and I'm saying, Judge, you're being fed the wrong information, my suit may not look as goofy as this guy's, but I'm probably standing out just the same way. I mean, and that's the truth. The judge, like, first case, and probably everybody who's heard this from me, they've heard me say it many times. The first time I'm a commercial lawyer, my client Julian Bivens asked me to go up to Palm Beach from Miami, just please get my dad back to Texas where he's from. He'd allowed his dad to get into a guardianship for this because he thought it was a good thing. Oh, well, somebody will watch over my dad while he's in Florida. But then they wouldn't let him out. Well, Ron, can you go help me get him back to Texas? Oh, this must be a no-brainer. Okay, sure, I'll go up there and do this. And you walk into this courtroom, I'd never practiced trust and estates and guardianship before, and you walk in and it's like, wait a second, here's law. It's not really being operated that way, and then the judge's like, you guys go outside, all you attorneys go outside. It's just me and all this other group. You go outside and you try and work this out. And the guy walks up to me, one of the guys, the lead attorneys, hey boy, there's enough money for all of us here. Stop rocking the boat.
Wow.
Honest to God.
Wow.
And I'll never forget that, and I'll tell that story to the dead dog. And it's now, let's rock the boat.
That's good.
I mean, that's exactly.
Well, again, like I said, if you don't have any Russian mob in your family, for you, we do have Ron Denman here.
Again, I want to thank my team, Mr. Foster. Yes, sir.
I want to thank George, I want to thank my daughter for the time and thing. And in my case there, when they don't want to associate with that. I'm a World War II veteran, I did 8 years regular Navy, the first part of it, I'm a troop ship. And this call coming out like that there, unknown to me what they're talking about, it's like that there. The A coming here represents the state, telling me that they're gonna put me in a home for the care like that there, because I can't handle anything anymore, like finances or whatever it is like that there. And I told her, I said I wasn't ready for anything like that or anything else. And she said, well, I think you're gonna enjoy it. So that's when she left everything. It was a short time later, she met me again in the condo with the A, coming in and telling me then that the A is gonna be my guardian. So the thing I have to do, I have no more say to do anything with it. Like that. And that's the way they were leaving it. In regards to me like that. And then the other thing with this A, it was really something else. He saw me twice in the condo, and a couple of times in my daughter's house, like that there. And when he got talking with me that, and then actually says to my daughter, I want to talk to Mr. Foster in private. And my daughter says, go into the spring house and talk. And the first thing she says to me when she gets in there, Mr. Foster, when are you going to go back to your condo up there like that? I said, I'm not ready for my condo. I'm very happy with my daughter, and it's a family affair. And she tells me a story about her father. Her father was in, and I guess he was about 96, 97 years old. And he'd been to about 103 when he died because of the care that he was getting there. My response to that was, well, good luck, your father had a good time, and that was the end of it. But when she was leaving, she said to my father here, I'd like to have the keys for the condo. Oh, and she said, I just want to check that thing out and see what they have up there. So we gave her the key like that there, and they did go inspect the thing up. They took all the things that they thought I need. They took my money, everything, all like that there. So I was having nothing like that there because this is what we're taking on me. Until they tried to take the money that I had and they that's another thing like that there. The whole thing coming down the line was the bottom line. They left me with nothing and they're going to put me